So you want to get it, you want it,
it.
because if you snooze, you lose. Isn't that how that goes? Yeah.
Those Latin phrases always confuse me. Joel Henriot likes to quote George Costanza, who says, "It's not a lie if you think it's true." And
Okay, Mr. Barker.
Thank you, Your Honor. As always, Your Honor, over the lunchtime, I had a chance to reflect on some of the comments made here by the court and by opposing counsel, Mr. Polsenberg and Mr. Cavanaugh. And I'm gonna get back to the case analysis, but I want to throw a couple of things in front of the court. Go to slide 20. Mr. Godfrey. Connor, I wanted you to see this because I wanted to address something that you said I thought was really, I don't know if everybody caught it. I thought it was a very good comment. I thought it was insightful and required me to address it. You talked about reliance. Chris Kemper, the vice president of Terrible Herbst, executive vice president, the top dog, I believe, under the Herbst. This gentleman was designated as a 30B6 witness. And certainly the court understands the implications of a 30B6 witness's testimony. That's October 3rd, 2023. Your Honor, and he was the gentleman who also during the evidentiary hearing admitted to submitting two inaccurate declarations and inaccurate deposition testimony. But I want you to take a look at the second declaration. When we were here the last time, we talked about the first declaration. His second declaration, and this is dated, the hearing date was scheduled for January 23rd. He signed this January 19, 2024. He says here in his second declaration, in my role as Terrible Herbst Executive VP of Administration, I am directly involved in ETT's appearance in this matter. ETT1's Chief Information Officer, Brad Sexton, was the person who rebuilt the server so that searches could be conducted and who oversaw conduct of email searches utilizing certain search terms provided to ETT in order to respond to the discovery request. Now, we went through this morning all those search terms. Next paragraph. ETT search for documents responsive to the request for production in the related case, Henry, which is the case we are here for today, yielded additional emails that ETT search did not find when responding to the discovery request in this case. Your Honor, I don't know what Mr. Cavanaugh could say on behalf of his client ETT that is more convincing than the fact that the 30B6 Terribles indicated that in a search for documents related to our discovery request, this is the extent of what they found. Not 271,000 documents at the time. Your Honor, only 209. Using the search terms we provide, which were identified in our discovery request. Your Honor, there is so much information that we've discussed already, but if Mr. Polsenberg would get up and say, and I don't believe he's gonna say this now because of the last comment he made before we left for lunch, we should be able to rely on the veracity of deponents. What message, in terms of deterrence, what message do you send if you're saying that 30B6 witnesses, or just any witness, party witnesses, can lie or give an accurate testimony when it's convenient in one case, and then indicate to the court that you can't use that against me when I provide or fail to provide documents in a coordinated case. We did the coordination of discovery so we wouldn't have to repeat depositions of everyone in each case. That was the whole point of the coordinated discovery. And that's what he said. Paragraph 4 says, ETT's team was not previously aware of these emails when its counsel responded to the discovery in the case. That's fine. They weren't aware of it. They became aware of it, and I'm not here to cast blame in terms of Cozen O'Connor not informing their clients. Obviously, it wasn't done. That's something the court can address in terms of the 271,000 pages that weren't produced back in January of 2024, or back in November of 2023, or even as far back as May of 2023. But what we do know, given the 30B6 testimony, is that they believe at that point that they produced everything. At least that's what Mr. Kemper's declaration says. And then it says number 5, paragraph 5, ETT1 believed that the specificity of the request in Henry, as well as the timeline in the Henry plaintiff's consumption of real water and injuries from 2020 to 2021, led to the recent discovery of these emails. ETT had not previously discovered these emails when attempting to meet its discovery obligations, and was not intentionally hiding them from plaintiffs. And then it says, paragraph 7, ETT's team responsible for preparing discovery responses recently discovered the emails and was actively working with his counsel to disclose them as appropriate when plaintiff's counsel received the email inadvertently sent to ETT1's counsel. Your Honor, there is no excuse that can be offered for this delay in the production, this withholding of information. And in fact, Kayla Adams, as I pointed out earlier today, testified that she had not done a search. Each one of these declarants indicated that they checked their own emails and didn't find them. So let's go back to page 37. Again, this is where we left off, Your Honor, comparing the facts of this case to the Valley Health Systems case. And certainly, Your Honor, when you look at what has occurred here, the conduct of ETT or Terribles is much more egregious in this case. When you compare it to Bahena, next slide, please. Bahena, they failed to provide verified interrogatories, failed to timely produce a witness for deposition, to authenticate voluminous documents, and caused repeated delays in discovery. That was enough. Your Honor, it's much more egregious here. Not only do we not have verified interrogatories, we have inaccurate responses in interrogatories, inaccurate responses to request for production documents, false affidavits, or declarations, false testimony, not only from witnesses, but 30B6 witnesses, all leading us now to a week before disclosure discovery, no way of incorporating these documents in our discovery, no way of redoing all of the depositions, no way of getting our experts up to speed on these documents. It's impossible. Next slide. And on again, from the 290 pages, first it started at 11, then 290, then now 271. And in between the 290 and the 271, Your Honor,
271,000.
Thank you, Your Honor. 271,714 pages. In between that January time period and now, they waited until just the last couple of days to supplement their responses to our request for production. They still haven't supplemented the answers to interrogatories. Now let's get to the Johnny Ribeiro case. And Your Honor, we believe truly that these factors are ones that you will consider at the time or following the time of the evidentiary hearing. As you hear all the evidence and you hear the testimony of these witnesses, that's when these considerations are made. And that's when you consider all of the factors pronounced by the Supreme Court in this case. If you could, Shane. When we compare and contrast the factors in Johnny Ribeiro versus the facts of this case, Your Honor, certainly in terms of the willfulness, each of these individuals signed those declarations, knowing that either they didn't search, or if they did search, they withheld documents and then gave inconsistent or inaccurate sworn testimony. That's what we do know. And there's no way around it because they're the own witnesses. Mr. Kemper, each one of them admitted to it. So we know that. And what Mr. Polsenberg likes to say is, well, that was in the past. No, when they said it then, gave that sworn testimony in that case, they were also referred to this case. And they were not given accurate information then. And now it's finally caught up because 290 pages have turned into 271,000 pages. So the willfulness certainly weighs in favor, not only of an evidentiary hearing, but ultimately the striking of their answer. But that's again, the court, that's something that comes after the court hears for itself the testimony of these witnesses. There is no lesser sanction that we can think of, Your Honor, that would remove the prejudice suffered by the plaintiffs, because we can't redo everything. It's impossible. It is practically impossible to redo everything that should have been done before, retake all the depositions, to modify or make more precise some of our written discovery requests based upon these documents, to question these witnesses on the documents, to use the documents for further discovery efforts, to give them to our experts so they could include them in their analysis and their reports. They're all done. The initial reports are done, the rebuttal reports are done. Number 3 is the severity of the sanction relative to the discovery of use. Your Honor, in every case we've shown you, and I don't think Mr. Polsenberg can think of others where the conduct was more egregious in terms of discovery. It all weighed in favor of significant sanctions, and that's what we're seeking here. Next slide, please. Now, it's our belief that the discovery should have been produced in 2021, because, and you'll see in a second, Your Honor, these cases, Henry, Wardson, Gallagher, the complaints, the operative complaints are the same. The causes of action are the same. We were seeking exactly the same damages for different plaintiffs, but the relationships form the basis of our claims against them with real water, as well as, of course, punitive damages. Number 5, sanctions being requested do not operate to penalize defendants for misconduct of their attorneys. I have not said a negative word about my friend, Mr. Cavanaugh, since I've been here, today or the last time, on the 7th. Other than asking him to take notes and wait till I get finished. That's other than those 2 things, but I would do the same for him. But I know he's passionate, and that's probably why he's gotten up and interjected, and I'm not upset about that. That's what he did, and I'm fine, Your Honor. But I'm not bringing this down to the lawyers. What I am bringing this down to is the clients. Because Terrible Herbst in each one of those executive held positions, they said they searched their own emails. That's what they said in their declarations. And these emails that we found within these 271,000, they're their names on them. They came from their emails or were received in their emails. So this is not a criticism of Mr. Cavanaugh. Number 6 says the defendants and all future litigation. Number 6 is the policy favoring adjudication on the merits. Your Honor, that's what Terrible Herbst has done to itself. It has prevented us from trying this case on the merits because they withheld the documents which would allow us to try this case on the merits. They can't use that factor as a sword and a shield. So that's what they've done. Their conduct has prevented this case from being heard on the merits. And we shouldn't suffer a penalty for their misconduct. Number 7, it says whether sanctions unfairly operate to penalize a party for misconduct. We just discussed that. And then the last one, the need to deter both parties and future litigants, Your Honor. Certainly, we cannot send a message that if you fail to produce or withhold this quantity of documents until the last possible moment, that's going to be condoned. We cannot support or send a message to litigants that it's okay to submit false declarations or give false testimony in depositions. We can't do that. Our rules are designed to do just the opposite. You're supposed to provide the documents. You're supposed to be forthright. You're supposed to be honest. So that's what we know wasn't done. Next slide. Now, this goes down to prejudice. And again, I think you will, after an evidentiary hearing, you can hear for yourself and see the exhibits. You'll have a better and fuller understanding of the prejudice plaintiffs have suffered, but we know that they failed to identify documents. Even if you use Mr. Cavanaugh's date of July 24, 2024, Your Honor, that was after plaintiff's expert reports were done. It was after we did all our written discovery. It was too late to do anything else. The document also revealed dozens of new witnesses that have not been deposed. It's too late to take those depositions. It's too late to send discovery related to those witnesses. Just 2 witnesses were enough in the Valley Health case. Next one. This is what I was just saying, Your Honor. We're unable to take the depositions of these witnesses identified in these new documents. Now, these documents and the witnesses identified in these documents, those depositions should have come long before our experts' reports were due. And they weren't. This should have been done as a part of 16.1, should have been done in response to our request for reduction, which took place back in October of 2023. Number 6 is that, number 5 says the names and companies that have been subpoenaed and deposed and summoned for trial. We can't do that. Some of the 200 partners, supplier partners for Terrible Herbst, we didn't have all those names. We couldn't follow up on those. Number 6, experts did not have the benefit of these witnesses. That's true. We discussed that, Your Honor. They didn't have the benefit of the transcripts. They didn't have the benefit of documents. They didn't have the benefit of us following up through further discovery of those documents. Number 7, we discussed this, but the main point we haven't discussed in terms of 7 is we don't have the benefit of these documents for purposes of dispositive motions or motions of limit.
But you know what, it's actually much more layered than that. Because, for example, I don't know exactly what potentially could happen, but here's my concern. For example, if you're not given all the documents, potentially that could impact your theories of liability. For example, you could move to amend the complaint based upon discovery, right? I mean, it's really layered. It could impact how you prepare your experts and expert theories. It could impact whether you file motions in limine or motions for partial summary judgment. It's a systemic issue, and that's why I come back to this one point, because it's so overlooked. And they say, well, you can do a do-over. Well, no, you can't, right? No, you can't unless you pay for the entire litigation and start from square one. And you don't do that. And this is another important point, because I think this is overlooked, because I don't mind saying this, as a lawyer, I handle complex litigation. That's right. I did, and I understand the importance of how you set your case up, and then you're down the road shortly before trial, and you find missing evidence that should have been produced in the case. You don't just say that, well, go take their deposit. No, that's not how it goes. It really doesn't. It's such a disadvantage. It just is. And I'll just tell everyone this too. I'm really concerned about false testimony. I mean, and false declarations. That goes to the whole integrity of the process. And then I understand it's a coordinated case, but that discovery was going to be used in this case. It's not like we're going to take the deposition of the person most knowledgeable on specific issues on behalf of Terrible Herbst 5 times, one for each case. I don't think that was the agreement when the cases were coordinated, and that's my concern. I'll just say that for the record, because it's layered. It really is. And it's easy to say if you haven't been involved in complex civil litigation, I'll just do a do-over. No, you can't do that.
If you could go to number 5, I'm sorry, number 45. Oh, go back, you're right, Jane, I apologize. And so, Your Honor, getting back to the merits, as a result of terrible misconduct, it's impossible, we believe, for the jury to decide plaintiff's case against Terrible's on the merits.
And what do you mean by that? Tell me what you mean.
So this is the problem. To really develop the merits of the case, we would have had these documents, we believe, since 2021. We could have gone through with each of these witnesses, tell me your history with Real Water. How were you involved in the promotional activities, the marketing activities? Did you add or take away from the commercials? How often were the commercials played? How were you selling these? You know, how did you, and using Mr. Anthony Randolph's testimony, how are you such an integral part of the development of Real Water? None of that stuff we can do now because we didn't have these documents. They were denying everything that we thought was the case. Just flat out denying it, denying that it was happening, denying the relationship, denying the documents, denying the communications, the emails, the contracts, all of those things were being denied.
Objection, misstates as to Henry.
So, Your Honor, without being able to develop have those depositions with those documents available, we don't get the testimony. That's the merits of the case, the documents and the testimony. And we don't have it. We just don't have it because of their misconduct, their withholding of documents. And I thought it was strategically done to prevent us from being able to do it because they've done it so late. July 24th? And you're right, Your Honor, the date to amend the pleadings or add parties, gone.
To add theories of liability.
Gone, all of that. So when you go to the next, go to the next slide. This is the Hunwartson complaint, Your Honor, and the Henry complaint. One filed 2 years after the other. Terrible Herbst is in both of them. In both cases, their obligation to produce these documents started in 2021. Because these emails aren't about Henry per se, they're about Real Water and the relationship with Real Water. Mr. Cavanaugh says, oh, then it's only important if it involved Henry. No, Your Honor, in the Gallagher case, did any of the documents between Real Water and Hannah or Milwaukee specifically mention Miss Gallagher? No, it's not going to mention any of the plaintiffs, but it will represent the relationship between the distributor, the seller, and Real Water. So when we're asking about communications with Real Water, we didn't say, give us communications with Real Water related to Henry, or to Quante Henry, or to Mr. Brown, or anyone else. Give us documents related to Real Water in your communications with them, their contracts. Those documents should have been produced in 2021.
So if he would have developed the relationship issue factually, what would have been your request?
Oh, perfect. So if we had these documents in 2021, the 2,271,000 pages of documents, if we had those, Your Honor, we would have had the benefit of using them in each of their depositions. We would have had the chance at that point to say, you know something, in terms of punitive damages, Terrible Herbst, you were not just a seller, but you cooperated with them in how to develop the sales of Real Water. You are much more involved in Real Water than you pretended to be, because they said they had no real relationship. That's what they said.
Circling back to what we talked about earlier, joint venture theory?
That absolutely, Your Honor. Absolutely. When Anthony Randolph said he learned a lot from them on how to market and promote this, we're saying, okay, where's all the documents? And they kept denying. So I had to bring this to court's attention because I wanted the court to see that from March of 21, Terrible Herbst knew the claims. Second page, first cause of action, both strict liability. And then you know what that means, Your Honor. Everyone in the chain. And so did Terrible Herbst and its counsel. Second cause of action, breach of implied warranty of merchantability. Real Water and distributor defendants, Your Honor. Next. Negligence per se, adulterated product. You know, it just, Your Honor, it goes on and on. It's the same claims. And so Mr. Cavanaugh takes this myopic view because the word Henry didn't show up in an email. That's not what's required for punitive damages. It's not required, that's not what's required for strict product liability. They tried to diminish their role in this product and its availability to the marketplace. That's what they, and tried to distance themselves from Real Water. These documents prove just the opposite. And we needed to show that relationship, and they tried to hide it. That was the whole point behind what they were doing. Your Honor, again, looking at this case, page 54, slide 54. This is Terrible Herbst's answers to requests for admissions. This was done on December 4th, 2023 in the Henry case. I point this out again to say they were denying these requests. They were trying to distance themselves from Real Water. That was the whole point.
Should you leave it up for a second?
Sure.
Well, it keeps flashing back and forth.
Let them see request number one. Shane.
Can we see the whole thing? The whole page?
These are your answers, but that's
They're not
fine.
my answers, but I'd like to see the whole page.
That's fine. 54, please. Let them see 54. Good enough?
I'd like to see the page with the answer. it's been
You said you
changed.
want to see the first page. This is the first page. Okay.
We can start with requests for admissions,
Yeah,
number one.
Your Honor, I just wanted to read this one page. It's okay.
There we go. And when you're done, Mr. Cavanaugh, we'll move to the next.
And we can highlight a request number one, so I can.
He's got the titles.
And the first page again.
No, you don't want the first page, right?
I do now. I've read the second. I wanted to see the first. So these are responses in 2023 before any supplemental responses are given. Okay.
Yeah, I want to see specifically what each request for admission was, so that, I guess the first. Number one, commercials on gas pumps. Okay,
Denies. After the.
let's go to number two.
Denies.
I believe they're the same request, just in different years.
That's correct, but I wanted to see the court to see that they denied both 16 and 17.
Let's go to the next one.
And denies.
All right, I see.
2018. 2019, again, denies, Your Honor.
And Mr. Cavanaugh's correct, there is no supplement because Terrible Herbst has not supplemented its responses to these requests for admission.
Again, an obligation they have under the rule, Your Honor. So as we stand, that's the operative responses to the request for admissions.
I believe they were supplemented, but I don't have any proof of that as they sit here, so I don't know.
Your Honor, at the last hearing, I showed the court Terrible's fourth supplement, which was produced on July 24th, 2024. This is page 56. And you can see the date electronically served, Your Honor. I provided a copy to the court. This is where the 271,000 pages of documents were disclosed. But the first couple of pages shows the 16 insurance policies, 1,498 pages of documents that were also produced.
What was the list of topics that 30B6 was set to testify on?
Your Honor, I don't know if I have that with me. We can have, maybe we can pull it up.
From
Yeah.
Mr. Kemper.
I think
Yeah.
it was Kemper.
It was
Yeah.
Kim. Your Honor, well, Mr.
Are you looking that up or what?
No, he's looking.
Oh, okay.
I don't wanna not move on if we can.
Try to get an email and bring it up for you, Your Honor.
That's fine.
You know, I wanted to continue if I could.
Yeah, we
Okay,
absolutely.
perfect. If you could go to slide 69, please. Your Honor, this is just what we've been able to come up with so far. Trying to go through some of this 271,000 pages. This is just a chart of emails regarding meetings between Real Water and Terribles.
How many meetings? Any idea?
I didn't count them, Your Honor.
But the meetings, I mean, I'm just taking this at face value. Does it appear that the meetings first started on 6/20/28?
Yes.
2008, I'm sorry.
That's right, Your Honor. Oh, wait, all the way to the last one of November 5th, 2020. That's only 4 months before it was pulled off the shelves. On the second page.
And there's 25 listed here for the record. That's unlikely to be all inclusive.
And that's the problem, Your Honor. We haven't been able to get through all the documents yet. We're trying to put this stuff together as we go through it. But that's what we've been able to determine thus far. Which highlights the problem when you get 271,000 pages this late in the game. If you could go to 72, please. Your Honor, these are some of the emails we found just on commercials. And remember, they denied any commercials. And these are 2013 through 2019, Your Honor. Next, slide 74. These are emails regarding the impulse communications that we've been able to find, Your Honor, and we got 2 pages of these. If you could go to slide 77. Your Honor, these are emails with Breeden and Anthony Randolph. Again, just ones we've been able to pull out in preparation for this. And Mr. Breeden was the one who said he wasn't not even aware with the name Anthony Randolph. And you can see all of these emails between him and Anthony Randolph. Next email, next exhibits 80, please. These are individual emails we found from Ryan Prince dealing with Real Water, Your Honor, from 2016 through 2018. And all of these are part of this 271,000 pages revealed in July of last month, July 24th. Go to 83, please. These are emails related to Mr. Walters. Again, all of these declarations saying we had no communications with them. We have no emails with Real Water people. And Your Honor, you can see we have 2 pages with several emails going from 2008 all the way to May 21st, 2020 from Mr. Walters.
These are in between people at Terrible Herbst, other people at Terrible Herbst.
They deal with Real Water. Your Honor,
Mark Walters to somebody at Nevada Beverage, somebody at Terribles to somebody else at Terribles.
Your Honor, I don't know if Mr. Cavanaugh is arguing or just talking.
I'm just pointing out, we haven't seen these documents
They're your
in this
documents.
form. Well,
That's
true.
fine.
I don't know what they are.
That
She didn't
again,
produce them.
that again highlights the prejudice of what we're dealing with.
Well, everything, it doesn't go
You're-
one way.
And this is all I'm gonna say on this issue. And I understand why you have to have document production early. We have strict rules regarding discovery cutoffs, expert designations, motions to amend, summary judgment, dispositive motions, and all those things. And just as important too, you need documents. You can have legal theories. But to be really candid with everyone, you might not even have a legal theory that might be viable until you get the documents and stuff jumps off the page. I mean, and this is, it's not, this isn't a simple rear ender. Right? Even those can be complex from a medical perspective sometimes. So I don't want to denigrate rear enders, but but factually, they're not as complex. But maybe from a medical causation, it can be. But I can see where, when you look at it from this perspective, because you get documents and you don't get them during the course of discovery, maybe they will disclose nothing. Maybe they disclose a lot. But you can't make that determination until you get the documents.
If we could look at now, slide 86. These are emails between Mark Walters from Terrible Herbst and related to Mr. Anthony Randolph from Real Water. And we got 2 pages of these documents, 2 pages outlining emails from 2011 all the way through June 18, 2020. All of these are new documents that were not previously provided. We have we found the 30B6 notice of deposition from Mr. Kemper, Your Honor. You want us to pull that on the screen?
Yeah, pull it up. I just want to see his topics.
There we go. You can make it bigger.
Okay, the first deals with audits, right?
Second one deals with distribution agreements, shelving agreements, purchasing agreements entered into with the manufacturer, which would be Real Water. See, this one specifically mentions Nevada beverage relating to Real Water.
I can't read that fast.
Slow down, Mr. Polsenberg.
Just don't call me old, Ted.
I would not. We have a few days older than me, I think.
I thought you were gonna say only a few days left.
Oh, that wouldn't be a good thing.
That would not, that's something I would say.
I did do my cardio.
Still beat me, Judge. I did on Sunday.
Good for you.
Okay. No, two.
Go out. Go back.
Hang on. Okay, thank you.
Now, Your Honor, I want to show you before we get off, before I get finished. A couple of these emails that were produced. Shane, if you could go to THSETEC 46465. I'll show it to you. I believe you have this.
You know, if this was attached to a motion.
It was one of the documents we used to put together the chart. Oh, thank you. Your Honor, this is just one of the nuggets, gold nuggets, I would say, that we found. We have a lot here, but I'm not gonna go through all of them. I'll save these if the court permits an evidentiary hearing.
No. You can't save stuff for the evidentiary hearing. I need to know what the case is against me.
Your Honor, these are their documents. They have the ability to go through their own documents.
No, I don't have any obligation to present a defense if they can't present a prima facie case of willfulness and prejudice. This evidentiary hearing, if we have one, can't be a game of surprise.
No, I agree with that. I understand what you're saying, Mr. President. Okay, but I'm looking here and apparently it appears to me to be a email from,
Brian, it was to Brian Breeden. And Richie Griffin, but it's related to Rio Water. And in fact, it says, second sentence says, also at 148, which is the store number, Your Honor. The inside TVs are only playing one commercial, and that is for Rio Water. And I'm sure the court remembers all of the denials to all the commercials for Rio Water. Be it declarations, be it responses to written discovery. That's what.
I'm gonna object to that misstatement.
what's the objection? Mr.
Just
Gav-
stating the facts of what was said, said they could not find the commercials. They didn't say there weren't any commercials that they knew about.
And what was the date of this email? again?
2019, Your Honor. And if you remember, we went through each year.
I remember.
If you could bring up THSETEC 81766. All right, thank you. Your Honor, this is an email from Anthony Randolph from Real Water to Mr. Breeden. And it says, hello, Brian, I met with Mark Walters yesterday, indicating there was a meeting, number one, and would like to set up a time for you and I to meet to discuss the marketing opportunities. Again, indicative of the relationship between the two companies you have available. Please let me know your schedule, when your schedule will allow. If you could go to THSETEC.
And Anthony Randolph, that's who again?
He is the marketing person for Real Water, the person that they denied even knowing his name during deposition. THSETEC 238854. This is June of 2020, Your Honor, this next one you're gonna see. And again, Anthony Randolph is the VP of Distribution for Real Water.
23885.
238854.
From a point of that, okay. No worries.
I can read it to the court. And this is dated June 18th, Your Honor, 2020, just to give the court some perspective. And it's from Anthony Randolph to Brian Breeden. The subject is Real Water. And it says, hello, Brian, we weren't going to give you free product. We're going to give Nevada Beverage free product. And they were going to charge you a cost of $250 per case. You will then invoice me the $250 per case for the amount that it was redeemed. You will still have a cost. It will just be discounted for the promo. Does that not work for you? Showing the relationship between not only Real Water and Terribles, but Real Water, Nevada Beverage and Terribles, and how they were discounting or giving free product through a third person for Terribles. Your Honor, when Mr. Cavanaugh was talking about relationships, this is a type of documents that would show exactly the kind of relationship they had. Documents we didn't have during the depositions. I'm going to show you another one, Your Honor. If you could go to I don't know if you have this one, Shane, THSETEC 15703. 15703. Oh, you did find the one? Yes. Okay, good. If you find it, put it up. I'll read it to the court. Your Honor, this is 2016. And it's an email involving Richie Griffin. And it involves Real Water. And it says, I've attached the Real Water campaign, but I figured I would also link you to some other examples of advertising. And it's showing videos, promotional videos for their Real Water campaign in 2016, Your Honor. Here it is right here. Where they've denied in all of this discovery, relationships, communications, the knowledge of these people, promotional commercials, videos, all of those things, Your Honor. Now I want to show you THSE.
Can we see the top of that email? I'm sorry.
No worries, Mr. Cavanaugh.
This is says Skylar at the top.
This is, the one I'm looking at says Skylar at the top, right above from Duval.
And who is Skylar?
Well, you know, it'd be good if we knew, because we.
It tells you in the email address. It's Mike Hard Liquor.
It said from the,
What's
above it
this got to
says
do with-
Skylar Mills.
Yeah.
Okay.
Do we know who Skylar Mills is?
Yes, your honors. What this email is depicting is an employee from Terrible Herbst communicating with an employee from Mike's Hard Lemonade about commercials. And he was helping the Mike's Hard Lemonade person with what commercials Terrible Herbst has run. And as part of that email chain, he sends him an example and attaches the Real Water commercial that Terrible Herbst has denied for years and still denies to this day that it ever played or ever has. So this is just further proof that what they've said in their discovery responses and sworn deposition testimony and sworn testimony during the evidentiary hearing is not true.
So I'm gonna show you the next one. THSETEC 629. This one identifies Mark Walters and Chris Kemper, Your Honor. January 2nd, 2013. And at the top, it references Tim Herbst of the Herbst family.
It's 2013.
That's correct. At the bottom, it says, Uproar Advertising submitted Real Water to be placed on the media system. Chris had me remove it. Is it okay to put it back up? So now, all these years, all of these discovery responses saying there was no commercials or advertising. And here is an admission that it was up at one point. And they're considering now putting it back up. As early as 2013, Your Honor. And that email had Terrible Herbst on it, Chris Kemper, Mark Walters. I've shown you an email from everyone that has given a declaration except for Brad Sexton, and Brad Sexton himself said in his evidentiary hearing that he gave an inaccurate declaration. Kayla Adams said that you could find these things with just a stroke of your computer system. And yet they were withheld since 2021, in our opinion, but at least in terms of this case, since December of 2023.
Objection, misstates the evidence, misstates her testimony.
Your Honor, I don't believe that the court is required to do an evidentiary hearing right now. And the reason I say that is because I believe the court should schedule it. But Mr. Cavanaugh, I think, may be confusing what is necessary for the court to decide to have an evidentiary hearing and then determine what sanctions would be appropriate, if any. And that comes after the court hears the testimony. But given the numerous inaccurate or false statements included in declarations, depositions, 30B6 deponents, written discovery responses, Your Honor, there is more than enough to warrant an evidentiary hearing. Unless the court has any questions, Your Honor, I will cede the podium to Mr. Cavanaugh and Mr. Polsenberg.
Okay, thank you.
Thank you.
Mr. Cavanaugh.
It's been about an hour. Can we take a break here?
Oh, you can. We can continue on, Mr. Cavanaugh.
Good afternoon, Your Honor. Jim Cavanaugh for ETT one LLC, DBA Terrible Herbst. I'm going to start with a few preliminary points that are in our opposition to the first motion that was filed to strike our answer in Henry. Prior to the reply and the supplemental reply. First, Your Honor, it was our belief that this matter should have first been brought to the special master pursuant to the case management order number 1 in this case. It's exhibit A to my declaration in support of the opposition to the motion to strike our answer or lesser sanctions. No notice was ever given to special master that there was a discovery abuse and a dispute prior to this motion being filed. No opportunity for the defendant to respond on a level with the special master. Arguably more equipped anyway to deal with some of the minutia of some of these emails and the various discovery dispute issues.
I have a question for you, because I remember I had Justice Maupin in here as a lawyer, post his tenure on our Nevada Supreme Court, and I had a very exact same issue, and I said, well, Justice Maupin, tell me, are you saying that I don't have the jurisdiction to hear this matter, this discovery dispute? And he paused. He says, Judge, you have the jurisdiction, because ultimately you make the decision if there's an appeal. But anyway, go ahead. I want to hear what you have to say on really what's going on in the substance of what we're dealing with.
Yeah, and I'll get to that very, very next thing. Exhibit B to my declaration, Your Honor, which was filed in support of this opposition to the plaintiff's motion, is the first supplemental disclosure in Henry, dated January 17, 2024, which included the 290 pages of documents, bait stamp TH 002346, to and including TH 002636. These also contained marketing materials which were discovered and produced. I've enumerated those by bait stamp number in my opposition. It should be pointed out that these documents were produced and made available to plaintiff, Paz and Holo, identified as marketing materials 7 months before the close of discovery next week, and 5 full months before and prior to any of the of Mr. Henry's plaintiff, Henry's initial expert disclosure deadlines. There's no apparent effort ever been made to look at those, review them, refer to an expert. There's no offer of proof. Maybe this isn't the place for what they would have done with any of those documents that they've had now for 8 months. I think that's a very important salient issue here. It's almost as though they don't want the documents, they want a sanction here now. Next, as pointed out in my declaration, Exhibit C are experts from plaintiff Taquante Henry's mother, who we deposed July 18th, I believe, yes. And she testified she never saw any Terrible Herbst commercials, never saw any Real Water ads, and she wasn't swayed to make any decision to purchase the Real Water product at Terrible Herbst because of commercials or ads.
Why is that
now are so
yeah.
important?
But why does that matter whether she as a consumer potentially saw those ads? Because I kind of look at this issue much differently, listening to what Mr. Parker was talking about. The thrust and focus of his argument has been this: look, Judge, we wanted to inquire into whether or not Terrible Herbst and Real Water had some sort of relationship. Not just a distributor relationship. Mm-hmm. And I think that's really and truly what the whole thrust and focus is. Is there something more? Because, from a, they're in that line of distribution, so they're on the hook anyway. but he wants to find out if there's something more to it than that. And that's why when he was talking very much earlier, and he was making a lot of allegations regarding the potentiality of the relationship. That's why I said, well, that sounds kind of like a joint venture and tort to me, and the reason why I bring that up, there's a whole line of cases and legal theories dealing specifically with that type of issue. And that's different than liability based upon being a distributor in the chain of distribution. And I understand that.
I follow you, Your Honor, and let me permit me to just say about that unless plaintiffs are willing to stipulate to the fact there's been no plaintiff proof of causation of Mr. Henry's injuries related to Terrible Herbst, I think this is very much an important issue. If commercials aren't that important, Your Honor, why have we spent several hours today dwelling on what
No,
commercial?
I didn't say they weren't important. What I'm talking about is this, and this, I understand this case. Factually, I know what's going on. And here's my point. There was discovery requests made and there was a denial of any type of relationship, right? Then we have the documents that were later produced, and it appeared to be something more than a manufacturer distributor relationship, right?
Is that a conclusion courts made?
No, and that's their allegation. I
Yeah.
haven't made any, that's their allegation, and they have facts that support it, because it appears to be there's something involved in marketing or something like that. And here, this is nuanced, but I get it, because lawyers are very talented and skilled. They are. I'm not necessarily referring to Mr. Parker or Mr. Pepperman, or it could be Mr. Kemp, but
Well, Mr. Kemp is.
yes, there's no question about that. But here's my point, though. And this is why these cases are so nuanced. And I like to think of myself as a sophisticated judge, right? And this is my point. When lawyers have certain documents and information in front of them and they prepare for a deposition, they can do wonders when they take depositions and start digging deep. And all of a sudden, the whole case turns based upon some facts or some discussions and some agreements and so on and so on. And here's my point. That opportunity was never presented because of the fact that the documents were not produced, and that's kind of where that's I think what's kind of being overlooked here. And I'm not making any findings right now at all. And from my perspective, it's more than anything observations. Because I understand what they're saying. They're saying, look, Judge, there's more here than a manufacturer distributor relationship. Right?
That's what they're saying.
That's what they're saying.
And there's no evidence it is.
Let me interject. If you're getting outside of those walls, you're getting outside of strict liability. So I know Mr. Kemp doesn't like to go to trial on negligence claims.
Well, I understand this. I guess it depends on maybe yes, maybe no.
It's an awful lot of maybes and mights.
No. Because in the law, there's a lot of maybes and mights. It all depends on the facts. And I have a question for you, Mr. Polsenberg. For example,
Should have kept my mouth shut.
Yeah, this is the question for you. You can answer this for me. Terrible Herbst is a distributor. Real Water's the manufacturer. If there was some joint venture between Terrible Herbst and Real Water, as it relates to the distribution of the product, why wouldn't strict liability still apply?
Strict liability would apply because.
That's a real good question.
But that's irrespective of whether there's a joint venture. If you want to pursue a joint venture theory, then you're looking outside of strict liability. there is no reason to have joint venture in strict liability because both the manufacturer and the distributor are held strictly liable.
Well, I understand that, but, and I understand 402A, restatement of torts and all that, I get that.
So-
But what does the joint venture component? Because typically when you have joint ventures, it's my understanding, you can have common liability, maybe based upon, 402A, or it could be some form of vicarious liability. And I understand this, we haven't ferreted that out, those are
You
the
don't
thoughts.
need I love talking 402A with you. I'd really rather talk restatement third, but that's okay.
That's gone.
Says that's before. So. if
Consumer
you're talking-
expectation, right?
Yeah, but this is the trial I just had next door on consumer expectation versus risk benefit. You don't have to worry about that. So if you've got standard strict liability, the manufacturer is liable, the distributor is liable. None of these other theories change that.
And Mr. Posenberg, I don't I understand that, I really do, but what we don't know and what we haven't developed, and I'm just making observations, if there's a joint venture, what impact, if any, does that have?
I think they would need to come in and tell you that.
I
And I
agree,
don't see one. What I see is that they are saying we were denied a fishing expedition to get into something that's totally irrelevant. Jim's pointed out it's irrelevant for causation in this individual case because Mr. Henry's mother did not see any advertising. It's irrelevant in the legal sense because there is nothing about a joint venture that is necessary or relevant in a strict products liability case.
I'm not gonna answer that, I have thoughts, I'm gonna leave that to
I did-
Mr. Park. No, I'm
I'm
gonna-
just trying to create residual doubt in you.
No.
So you don't have to express it.
No, it's not my job to respond to that
No, it's
necessarily.
not.
I'm gonna wait for Mr. Parker to respond to that, I have thoughts, but,
And I hesitated even bringing this up today
right,
because I can bring it up at the evidentiary hearing.
no, I
But
understand.
since you're asking, I'm telling you, you're on a fishing expedition to get into things that I don't think are violations, I don't think are prejudicial, I don't think are relevant.
Now I have another question.
Should tell them that.
And here's my point, and I have to I'm looking at the document issue, okay, that's part of it. And what do I do with the testimony and the recanting of testimony?
Those are two different things, okay? I think what evidence they have and need and didn't get to try the case is an issue that you need to examine to see what effect it has on the trial. Anything they did where they did not exhibit candor to the court, that should not affect the actual trial of the case. And cases say that discovery abuse shouldn't go to the jury. But that is something that's in front of you if it happened in front of you, and my argument is it didn't. But for you to address those issues, you can, and you can impose sanctions that don't affect the trial. And you can even do that after trial. You don't need to hold up the trial to get into an evidentiary hearing.
I get that, I feel that. It's not automatic, you get evidentiary hearings, right? I get
Right,
that.
and Judge, what I'm worried about, and Corey told me not to say this, but what I'm worried about is if you can say, all right, I'm gonna impose a huge sanction against ETT for stuff their employee said in front of Judge Kishner. Well, then they're gonna need ETT in every case down the line and try to get those same sanctions and get other judges or you in other cases upset about these things serially.
Now, are those other cases part of the coordinated cases here?
I'm sure they'll make them part of the coordinated cases.
Yeah, but I mean, right now,
No,
here and there.
No,
Okay, so that's different because there goes to a reliance issue that I brought up earlier. And here's my next question.
I would just want to qualify the no with, there's one case out there.
Yeah.
Somebody's made a
Yeah.
motion to bring into the consolidation.
So they
But
wouldn't,
currently, there's only Henry as an
yeah,
applicant.
and my point is this, my
Coordinate.
point is this, since they're not coordinated, there's no reliance as far as I could see it.
And I understand what you're talking about reliance.
Yes.
And there are other things that I'm saying are totally outside. Reliance, I understand is something we'd have to address, and that would probably be something for an evidentiary hearing.
Here's my next question for you, just going down that road, and I come back to this. Because, you know, when we talk about spoliation issues, you remember this case, for example, I think the real classic case that makes it really simple is Bass Davis, right? And we all remember Bass Davis.
Tape's gone.
Tape's gone. All right, you
And
know.
just so we can explain to Corey what a tape is, it's what we had before we recorded things on
Correct,
computers.
right. It was a tape, a videotape, it's gone. And the question ultimately came down to whether it was lost in the transit from, what was it, 7-Eleven, and Southland Corporation to the insurance company. That was the issue, right? And that was the allegation, and the court said, okay, you gotta make a determination as to whether it was intentional and or negligent spoliation, and it kind of
Right.
left it at that. And you know, what's funny about Bass Davis, it's overlooked all the time. It's a great collateral source case, by the way, and you probably know that.
Yeah, there's one. We'll talk collateral source. some
Yeah.
other time, but there's one squirrely Nevada case.
Yeah, But here's my question, and what is a trial court to do? When it comes to issues like that, because am I to view the evidence like a jury would?
I think you have a different, you know, back in the Fen cases, I used to argue to District Judge Jim Hardesty that a district court has a gatekeeper responsibility when it comes to what the jury will hear.
Absolutely.
He wasn't sure he agreed with me, and then when he wrote Leochi, you notice the word gatekeeper is in there.
And then it comes up again in Hallmark, and they said, look,
Right.
at the federal.
Oh, I
cases.
said Leochi, I meant Hallmark.
Yeah, absolutely.
So, I mean, two Hardesty opinions. So I think you have to look at it different ways in different contexts. If it's something that is less than candor to the court, you can handle that as a fact finder and as a judge in imposing a sanction, but that doesn't affect the trial. In looking at something that would affect the trial, you have to decide what the effect is going to be and what the jury finds out. So
I got you. I understand the distinction there. And the reason why I bring that up, when I look at the facts and there's allegations that there was, I'll just put it this way. Deposition testimony was recanted and or answers to interrogatories or whatever. You notice I was very benign on that.
And I commend you on that.
Okay, but here's my,
even
yeah.
the things we're hearing today were more benign than Teddy let on. It said we've looked for commercials, we haven't found any commercials, consequently, we.
Yeah, and the reason why I bring that up, as a trial judge, do I follow Nevada Pattern Jury Instruction 2.07?
You know, you're really good at playing stump the band. And you've got the Whitehead volume there
Oh,
from
yeah,
1986.
And you'd love
So I
it,
will never agree that any of those apply unless I look at
right? And you notice I have the Gallus or Earl Catalano and
it.
Smith.
Oh, wow. So.
This is a historic document, right?
I have a couple of copies.
Yes.
Joel Henry, I used to point out that I referred to it as a pamphlet.
Yes,
I wouldn't even call it a booklet. But I think we take it on. I am gonna agree with you. You need to get a feel for what happened here. I don't think there was willfulness. I've represented ETT for many years in different types of cases. I don't think there was any willfulness here. And I think you need to look at the prejudice. I don't think they have any prejudice. I think it's a fishing expedition. It may offend you that they didn't get stuff earlier. When Jim explains, he's gonna say, we thought they should have done more to get it earlier. That's fine.
no, and I remember Jim brought that up from the last hearing.
He did.
I did, there's no question.
That's probably where we're going next after we get through with causation and commercial.
Really, And I don't mind telling you, yes, I really enjoy this.
I've got client representatives watching. I don't think they're enjoying this.
I don't think they're on.
I don't know if
Is
they're on or
the-
not, but
Is the Zoom on?
Yes, yes.
that's why I have to be
We
very
can't see anything.
cautious, Mr.
That's-
Polsenberg.
I can change it, I can switch it
That's-
up.
Yeah, we probably don't need it. We
Well,
needed it
we-
more when we had the,
For that,
Do you need the doc count to present?
Interesting.
it's just good to have it on, so. if
not me,
somebody-
I don't use documents. I use American Sign Language.
Yeah,
Okay.
only when it's on our side. we're being-
Yeah. Okay, Mr. Cavanaugh, you can continue on, sir.
Well,
Because I remember we left off last week. I remember that. I do. I haven't forgot anything.
so can we return to that document then?
Whatever, you can.
So,
sure,
I
you
don't
can-
think-
I don't want to cut you off, but you can do whatever you want.
I appreciate it very much so. So if you look at paragraph 10 of the declaration to my opposition to plaintiff's motion to strike.
Okay, let me get to that.
Yeah.
I want to take a look at it and follow you, just like I followed the plaintiff.
I have additional copies of Teddy's May 28th letter to prior counsel requesting proposed protocol regarding forensic examination of Terrible Herbst. So with court permission,
If you have your copy of your declaration, you can bring it to me. See, if I should have it right here, but I'm not sure.
well, you need that, please. I do have a copy, just give me a moment. Here, I can give her, I've got a clean copy right here, you can keep it. Can I approach it?
Oh, absolutely.
Good point, good point.
Thank you, sir.
You will. So I was at paragraph 10.
And we're at paragraph 10 on page 6. Is that
Yeah.
correct?
Yeah, that's one right after we talked about plaintiff's mother. Didn't rely on any commercials or ads when she decided to purchase the product. So. What happens here is. Your Honor will recall the infamous 290 pages that were produced during the Hunwartson trial. In a first supplemental production in the Henry case by Terrible Herbst, CGT1. And those documents included marketing materials, etc. Following that, there were several supplements to some of the written discovery in Henry. And that occurred primarily in February, as I recall, Your Honor. I think that's the record. There was a period thereafter where perhaps folks were at Teddy's office or Mr. Kemp's office were satisfied with those supplements. Perhaps they weren't, but nothing really transpired regarding discovery in Henry by way of plaintiff demanding more or their dissatisfaction with the supplemental responses that followed in February. And then in May, for plaintiff's own reasons, counsel's own reasons, they decided they need to conduct a digital forensic exam of Terrible's computer systems. Prior counsel was still in the case at that time, and they agreed. And we were about to come on in the case, and we were told about it, and we agreed as well. Teddy's letter of May 28th, which I have another copy for Your Honor. I'm very much happy and want to actually give you a copy.
I think I have a copy of the letter.
I'd like to call it the exhibit D to the opposition declaration.
And we can do so for the record if you want to do
Okay, so
that.
we'll say it's exhibit D to the opposition at this point. Mr. Parker's letter, and specifically pretty terse terms, essentially says this is the protocol we want. If you object, let us know, but we want to go forward. And we have authority that says we can. And in paragraphs 3 and 5, they outline the computer systems they want to have digitally forensically investigated. And in paragraph 5, they list the search terms. There's 18 of them. Now, they're very broad. And they necessarily include, when you're searching Terrible Herbst computers for Nevada beverage, the exclusive, again, distributor of Budweiser and Anheuser-Busch products, they would necessarily include, and were produced in great numbers, additional documents that did not mention real water. Now, you've been shown today documents that did mention real water. And those are there. And I'll try to explain a little bit about that. But I'll tell you right now that a large number of the 270,000 documents were a function of paragraph 5 and those key search terms that Plaintiffs' Counsel insisted be part of the protocol. We did not fight it. We did not object to it. We proceeded to accommodate plaintiffs in their request for a digital forensic exam by their own experts. We gave them 2 days. I believe it's in writing and an email of June 6th and 7th. Plaintiffs asked for 2 days, so that's why 2 days. I think it became evident to them and everybody that 2 days wasn't enough time. And eventually, in June, there were 2 meetings on site at Terrible Herbst facilities. Plaintiffs' Counsel was participating in all 3 meetings. One was virtual, of the Applause Media Network, which is the advertising network that is used to advertise products that Terrible sells on the pumps. And in the course of those 3 meetings, was cooperation. There was never any kind of complaint or suggestion that help was needed to make Terribles comply. And they proceeded to get educated about our systems. And in that time, I informed counsel. I substituted in June 13th after the deposition of Mr. Henry later that afternoon. I had been talking to Teddy that month. And I explained, you know, we're doing everything we can with a digital forensic exam expert, CTEC investigations. I said, I am not going to filter what they get according to your protocol. We're going to produce it. They did that exam, and it took more than just a flick of a switch that Miss Kayla Adams allegedly thought would be sufficient to go through this many years. It went back to 2008, I think, up until the present, essentially, except for attorney-client privilege matters. And what happened next is we eventually produced those documents later in July. In the course of collecting those documents, we received an email correspondence from Mr. Kemp's office from Brianna, who I'm sure you know. Brianna attached to 2 emails, if not 3, another protocol. And I'd like to make that exhibit E to the record and give you a copy and share it with counsel. So the first time we got this additional protocol wasn't for us. This protocol was meant to be for plaintiff's own experts, Digital Mountain.
Oh, thanks.
Thank you.
Yeah, approach your honor.
Yes, you may.
Now, there's no date on this Digital Mountain protocol that I'm going to hand you. But I have an email here I can show you that was attached to this July 3rd, and another email attaching the same thing, July 8th. I'd like to focus the court's attention, if you would, below the subject line, image protocol. And if I could read it to the record, quote, upon receipt of the forensic images from Terrible Herbst, Ron Levy and David Dang of Digital Mountain shall follow the following search protocol. And as you read on, you realize that search protocol is 11 items, and it eliminates 7 very broad items from the 18 search terms that we performed. Our forensic digital exams expert performed, CTEC investigations performed the collection through. So they contemplated July 3rd, July 8th, the days that they sent this to me, doing a further follow-up to take the large body of documents that they could probably foresee when Teddy composed that protocol, that broad protocol, and they were going to whittle it down to this. They foresaw this was going to be necessary. They foresaw it was going to take time for them to do so in July at least. And the courts asked several times, how do we justify recalibrating discovery? There had been no discovery dispute other than in plaintiff's mind, their suspicion that whether it's rightful or not, that they hadn't gotten everything that they should have gotten. Independent of any explanation of why they didn't look at the 290 pages they already had related to marketing, which apparently wasn't, of interest to them to pursue with an expert at that time. And they proceeded, I assume, after they got these, albeit July 23rd or 24th, in our Terrible's fourth supplemental production, where it's spelled out how we arrived at these documents, the base stamp numbers. It attaches plaintiff's protocol, Teddy's letter, and attaches this protocol as well as what was also to be expected. Now, I want to point out right now, Your Honor, that today's date is the 16th. You saw a whole lot of documents in the presentation by Mr. Parker today. Replete with references somewhere. Maybe it was talking about we should do an ad similar to the one in 2016 that we did for Real Water for Ed's Lemonade or Rockstar Energy or something. Don't know how any of that would be relevant, but that's what the majority of these documents that even do hit on Real Water relate to. There's no smoking gun. And so anyway, that's how we got here with these documents. We accommodated, bent over backwards, nothing to hide. We didn't even get this in the form of a request to produce. We got this in the form of Mr. Parker's letter. We want to do a digital forensic exam. We'll do it. You can do your own. You can have your experts follow our experts. None of that part happened because they overestimated or underestimated the degree of difficulty. We spent scores of thousands of dollars to have CTEC investigations go in and do what our client was apparently unable to do. Now, you saw a reference in these documents that Mr. Parker showed you today
And when you say
to a rebuilt server that Mr. Brad Sexton had to work with. They rebuilt the server to try to find documents, and they apparently weren't successful.
here's my question though, when you say your client wasn't able to do so, what do you mean by that? Because I want to know what's going on from a backstory perspective.
Well, Your Honor, I knew a lot about Tennessee and Real Water, and I've been trying to study as quick as I can in this case, what happened. So, argument isn't evidence and by Mr. Parker, nor is it by me. But my best understanding is they had problems going back in time to accommodate these searches and figure it all out. Because the next document I'm going to show you, Your Honor, does go to that relationship kind of issue. Now, Teddy showed it, I think, briefly for, I think he was saying that I've over-relied on it somehow. I'm not sure how he knew I was going to show it to Your Honor, but, and maybe I am over-relying on it, but I think it's going to go to show, Your Honor, and I'd like to label it next in order and approach the bench if I could.
Yes, you may say.
And here's a copy of it. And what I've taken the liberty of not doing is I'm putting a Post-it on page 2. And that's the explanation of what this document is I'm going to show you. Because the first page of this document, Your Honor, it looks to be a couple of hundred companies that market their product in the digital, in the Terrible Herbst facilities. If you just take a minute to look, so the title on the second page, and again, I've been warned by appellate counsel not to have read too much into the word partner, but
Well, I can see why. I can see why.
Yeah, I mean, you're a lawyer, you're a judge, of course you can see why, but
Yes.
also common sense and experiences tell us that folks in the business, in the business world frequently use the term partner to refer to people that they do business with, not do business sharing profits with, but do business as a matter of commerce with. You even have, we've had, in the old CD days, Your Honor.
And
You
I
used
will
to
agree.
partner with insurance companies to get cases resolved.
Yeah,
People throw that
and
term
for the record, I understand there's a distinction between the legal
I
term, and that's what you're saying versus something that might be done as far as business relationships when it comes to marketing their product. I mean, I get it.
And please go back to the first page and look at who we're talking about. Turn back to page 1 of exhibit. We're gonna label this one, I think, DE. Well, this will be F, Your Honor. Digital Mountains Protocol will be.
Like, we don't call people
D.
employees anymore, we call them team members.
Yeah,
I mean, I get it, I
Yeah.
understand the concept.
yeah, a team member could get cut or promoted, but and bottom line, they're employees, right? So if you look at that first page though, and I don't want to prevent Your Honor from reading the second page, because that's the important distinction here between these references to partnerships and joint ventures. There's no joint venture, there's no written agreement that I'm aware of, and I don't believe plaintiffs ever put one up because, maybe they'll claim we didn't produce it. But there is no written agreement to share profits or be in a partnership with Real Water. Didn't happen. And the fact they delivered cases or they give people discounts in the real business world, that Your Honor's a business court judge, Your Honor is a very experienced, complex litigator and judge. These terms aren't meant to apply. We're in a partnership and we're going to split profits. We're doing business. I represent a local company. Dan's represented them for many years. I'm new to representing them, but not new to them as a business. They have thousands of products they sell in their stores. It's a family-owned business that grew up here in Clark County. It's become wildly successful, giving people fair prices and their gas and the convenience that we all use every week. I do, and have for years. And just look at the list of these businesses that are in a partner marketing meeting invitation. There's like one addressed to Mr. Rudolph at Real Water. I mean, but look at all of them. Look at all of them. Terrible's wasn't in partnership with these people any more than they were in partnership with Real Water, Your Honor. They were selling some product that they had no reason to know was defective or adulterated. They didn't know that. They had no notice of it. Also in these documents, the 290 pages, within something like 14 hours, Your Honor, they had pulled every product off the shelf and had emails, people confirming this was getting done the day they heard about the recall. But again, back to that relationship, the relationship information that's so important to this court, and understandably so, because we're off the causation. Now we're into the relationship that might speak to some kind of punitive argument. I don't want to interrupt, Your Honor. I know you're.
No, I'm fine, I'm listening to him. I was just was reading page 2.
So back to Exhibit D, the digital forensic mountain. That's still before you, Your Honor.
Yeah, I got it right
D
here.
is just one page says digital mountain. Plaintiffs
From Ron.
Plaintiffs forensic. Yeah, Ron Levy is
Yes.
one of the people that works there, David Dang. Both of these gentlemen were out at our facilities, Terrible Herbst, in their building a couple of times, as well as getting virtual tours of how the systems worked as well. But let me ask you a question about that, Your Honor. So they got these documents. July 24. They clearly got them and looked at them. You just saw a presentation here that is the envy of any lawyer that would like to present things. So that's what, 3 weeks ago? Where was their 16.1, Your Honor, on these documents that we didn't get to see prior to this hearing? where is their disclosure of what they believe was important enough to base their case against us? Yet they didn't produce those documents. They didn't produce Digital Mountain's forensic exam under these reduced protocol. I mean, if they did, I missed it, and I apologize, and that's on me, because I get a lot of emails I don't see always on time. But they just did their 21st supplement disclosure of documents and witnesses on the 13th. The 13th of August. Today's the 16th. And they did a 20th disclosure a few days before that, or a week before. All of that happened after they've had these documents that we produced in a searchable form. Now, I will tell you, the way we produce them, Your Honor, it is almost a click of the finger for people to go through now that we've spent whatever it was, $30,000 to get this in a searchable form. So how we got here, it wasn't a discovery problem that was being made known to the special master in any kind of meaningful way. They presented us with a demand to come look at our systems. We agreed in good faith. They didn't follow through. We kept doing it. Now, I don't want to make any direct assertion that we were set up, but a less charitable observer might think we were. But because we went ahead, and now the very documents that we went and had a professional digital forensic investigator search through documents back to 2008, almost genesis of the time Real Water was in business. So how did we get here? That's how we got here with those documents. And it's a pretty good bet here in Las Vegas or anywhere that if there is a evidentiary hearing, it's going to show a lot of those 270,000 don't relate to Real Water in any way. And even if they did, Your Honor, my client's in business. They're in business to sell products. And they had no reason not to be in business and do business with selling Terrible Herbst products, but they dealt through a distributor. A real, in the meaning, quote, distributor. They're a retailer. They get these products through a distributor. In this case, they got it in the latter years from 2010 on, to my knowledge, it's my belief, to Nevada Beverage Company, another defendant in this case. So how did we come up with these documents? Why and when? I believe that's relevant to your consideration of these sanctions motions. We can't go back in time and change the testimony of folks who didn't know the answers they thought they knew a year ago or even 8 months ago when these hearings happened. But we have done our best. We've done our best to come up with the documents that were demanded to be part of an investigation, a forensic digital exam the plaintiffs themselves didn't complete until after we over-corralled, under 18 search terms corralled from our computer systems and on the cloud and everywhere we could find 271,000. What were we going to do? Not produce it? We had to produce them. And we did, rightfully so. And that's how we got to where we are. And in terms of those documents, I don't believe that's blamable conduct. You know, the fact that people were looking on different systems, they weren't, you know, people have titles, but titles don't always fully and accurately or validly describe what people should know. If you're a vice president or a head of advertising of a product that takes up very little space or even a lot of space, if you got 7,000 products in your stores or whatever it is, I'm not sure if that's the number, Your Honor, but trust me, it's verify and trust me, but it's a lot of thousands of of products that are sold. So how, you know, Your Honor, I can't remember some clients from last year. Small cases, albeit, but can't. You know, if I did a computer search for Judge Williams, I'm gonna get a whole lot of cases besides real water. I mean, it'd be like me doing a search of Dan Polsenberg in the Supreme Court. And I might not get any of the cases that I'm really looking for. And that's part of what happened here with that large group of documents. Before I answer more of the questions, Your Honor, I just want to return to the fact that this case starts out complaining with vague allegations that they're not getting everything. Well, it turns out, according to their standard of what they thought was relevant, they didn't. It's evident they didn't. We had to get a professional that was capable, competent, an expert in doing a forensic exam. They found more documents that reference real water. Can't explain why that didn't happen before, other than people weren't as professionally capable as they could have been. They were negligent in their search, perhaps. But there were reasons. I mean, some person's looking on a Mac system that has a whole different way of archiving things. Some person's looking on a PC. There was a whole rebuilt server thing going on that was in Teddy's documents, if you recall. Yeah, we did do amendments to the request for production. We did them based on our fourth supplement. And in the amendments, supplements to supplements, we referred to the fourth 16.1 disclosure documents that we had produced. Not admitting that they have any bearing on the liability in this case of any sort, but that we produced the documents, plaintiffs demanded to do a digital forensic exam produced, we went ahead and did it. And that's how we got here. But Your Honor, we haven't even taken one expert's deposition in this case so far. They're all happening next week in about a 7-day period, just commiserating with Eric about it. There are ways to work around whatever prejudice plaintiffs might claim, but it's pretty much speculative. And the fact that they might come up with additional bases, you know, and this reference to 2021, we should have had it in 2021. Terribles wasn't even Mr. Henry's defendant until March of 2023, just a little over a year and 4 months ago. No matter what the case, Your Honor, in products liability, causation is an absolute element of the claim. And these documents, it's just speculation. There's nothing in here. Plaintiffs don't have that kind of expert teed up after we produced the 290 pages in January and amended the responses in February. Comments were made over the course of my good friend Teddy's Parker's presentations, and we had an opportunity at some point to address them with Your Honor. I might go through those and try to address those, but at this point, I also want to stop and see if you have a question that
I know, I'm listening.
Okay.
I'm listening. I'm also thinking, and
Okay.
there's a lot here.
Have I explained a little bit about how this has happened and why
Yeah,
where we're at?
You've given me your client's view.
Yeah.
No question.
Okay. So discounts and selling products by a retailer of a manufacturer, there's this, I'm sure Teddy didn't mean sharing profits, but he said it, and that's just, there isn't a shred of evidence. There's a profit sharing agreement. I explained why they received the supplements and the supplemental responses. And when we do the supplements, we put our additional information in bold. The fact that those previous objections have been made, we didn't remove them. We just put our supplement on top of them in Terrible's additional production. Mr. Chris Kemper, Executive Vice President's 30B6 deposition. I don't know how many of those topics were objected to. I don't know how many of those topics were actually utilized in his exam. But I do know those dates were all over the map. You could see some of them, they were asking about 2016 to 2022, or 2012 to 2020. I mean, there was a lot there, and a lot of it predated any kinds of marketing issue that I think could be more than just speculation, had anything to do with a relationship that Plaintiffs trying to paint. Just not evidence of it. It's speculation, but with all these documents produced, there's nothing here about sharing profits. And I've given you Exhibit F, which shows the relationship of all these folks to Terrible Herbst in the sales realm. There's no contract between Terrible Herbst and ETT DBA Terrible Herbst and Real Water. There's no argument that there is really. There might be a speculation, but it's not based on any evidence. I addressed, I think, the recalibration that the court is now forced to ask, why make your emergency our problem? Tried to explain my best to how that came about, Your Honor, and I don't think any of it was willingness, blamable conduct that merits a sanction. Certainly not anything that merits anything in the realm of striking an answer or something even close to that nature. You just can't overlook the scope of the request. I mean, that speaks for itself as to how we got to that many documents. Further speaks volumes that they did a reduced search with their own forensic expert, which they told me they were going to do in July. This was, if there was a partnership, was between us and Kemp and Jones and Parker Nelson to get to these additional documents. I would call that a partnership. One that, we readily undertook after we became counsel for Terrible Herbst, and Terrible Herbst couldn't wait to help get this thing straightened out. They don't feel like they had blamable conduct here because there was nothing willful about the failures in the past. Can't overlook the thrust and scope of the request. I get it, you can't. And you can't overlook the thrust and scope of Exhibit D, Your Honor, and Exhibit E. That's the request that's relevant to what now has become the motions to strike our answer over the recently produced documents that was engineered by plaintiffs' request. Not even a formal request for production. We did it. We did it willingly. We weren't pushed. We didn't object to it. You might see objections to the request for production, which also explains some of those answers. Those weren't textbook requests. I mean, they were valid requests in most respects, but those objections were relevant at the time prior counsel made them. Bear with me, Your Honor. I was talking to colleague Joe Ledoux. There was never an ESI protocol in any of these cases, even now. And so it's been a little bit of a moving target over these kinds of issues throughout most of these real water cases. I heard a minute ago a reference to, you know, why some of these issues were there was no doubt these documents should have been produced in October 15, 2021. Even there was a reference to Gallagher. I mean, first we're bringing in Hunwarts, and now we're talking about Gallagher, and then a minute later we're talking, and I didn't get that reference to what Hannah and Milwaukee Instruments involvement in these litigations were in any way parallel to what's happened here. I just missed it, Your Honor. I apologize. I don't recall what was said about it. But I don't see the reference. I mean, I don't see the analogy. A lot of loose, and I do it, but a lot of loose descriptors float around in these cases. And I hear the word over and over again, the word lie. And it happened in the examination of the Terrible Herbst officers. And then, you know, Mr. Parker or another plaintiff counsel would rephrase and misrepresent it or rephrase. I mean, when you really look at it, people made mistakes. They didn't know. They got hundreds of employees and thousands of products. And they just didn't know. They thought they knew and they testified accordingly, or their affidavit said so. But you know, what is the correct sanction for that in a subsequent case? Not a consolidated case, a coordinated case for discovery. I don't think the court should minimize the fact that they had to have a server rebuilt when they went about those investigations, and they had different computer systems. It was Terrible Herbst. It wasn't IBM with everybody had a 360/40 in their computer room that they were all coordinated with. They're good company.
I think that's the old days.
Yeah, remember those? But computers took up a whole room. And now we can allegedly go to the moon with our cell phone. I think Dan and you have addressed Rivero factors, and I want to give Dan a chance to talk some more about those based on the facts we've been discovering.
Didn't check with me before I said that.
Oh, my bad. I won't be the first mistake I've made, Your Honor. And I get it. I understand. I heard the court. The impact, the layers. I just explained some layers of these 270,000 recently produced documents. And the other layer, the other side of the onion, as you peel it, I'm still waiting for the Digital Mountain 16.1 documents that maybe would have made us more informed to be able to respond to the many hundreds of emails you were shown that there was some reference to real water. What there was there has got to be debated. It's got to honestly be debated rather than speculated about before a conclusion's made that it mounted to a hill of beans in this strict liability case. I understand the importance of giving accurate testimony. I'm not advocating for do-overs, but I wanted to explain fully how this recent group of documents that we essentially partnered with plaintiffs to produce, and that they have since, according to the documentation, reduced to half the search terms nearly, but we've not seen those in 16.1. I guess that obligation, you know, needs to be discussed a little more on their side too, to be fair, doesn't it? Talked about the objections, the overbroad, the proportional, not proportional to the needs of the case. Because these documents now have been found, that doesn't invalidate every objection that happened by prior counsel to a different discovery that came out. That needs to be kept in mind. And again, we left those as we were. we state right at the beginning of the supplement, new information in bold, underline bold, it's in bold. But that doesn't diminish the legal reasonableness of those prior objections. I mean, I'm still trying to figure out how information from the sales of real water in 2008, 2010, 2015 have anything to do with the case before Your Honor on behalf of Quante Henry. Just not, there's nothing malicious about what's happened here or what happened in the past. There's just no question about that. People are wrong. They make mistakes. And honestly, Your Honor, they never even didn't offer proof that they had an expert that would even dream up a reason to say that there was a marketing relationship that enhanced the liability that Your Honor could find enhanced the liability of Terrible Herbst for having sold a product that was later determined to be adulterated. I'm sure I have more here. It's been listening, for essentially better parts of 2 days, to a real good lawyer on the plaintiff's side, making his case. I just think it's critical to understand how we got here. And I understand Mr. Parker's a good advocate for his client. But Your Honor, seems to me a lot of this, I get the fact that a big part of the difficulty of Your Honor's job, even after almost 20 years on the bench and all your years in practice, is figuring out factual things that happened or didn't happen. But Your Honor, isn't that the province of the jury? And then shouldn't the jury have give our client the option to put his defense on that there's no causation for Mr. Henry's injuries attributable to real water? And we just want that opportunity. I appreciate your time, and I would like, if I could, to maybe respond if other counsel give me that chance. So
I'll listen to it if there's a point you want to make. No problem there. Mr. Polsenberg.
We all know I can go all day, all weekend, but I see the look on your face. I am not saying you prejudge the ultimate result. But you've a couple of times mentioned an evidentiary hearing, so I think you're gonna order one. So I'm gonna say.
I can tell you this, that's not something I enjoy doing. Is ordering evidentiary hearings. I remember the last trial, there's a question as to whether I should order an evidentiary hearing. Slightly different set of facts, but I get it. I'm sitting here, I don't like ordering evidentiary hearings, but you do what you gotta do. But I'm not saying I'm gonna do one at this point. But go ahead.
No, what I'm saying is I can see where you're going, so I'm not gonna argue.
No, you tell me why one isn't necessary, Mr. Paul.
Well, but I did earlier. It's because there is, I have to agree with Jim, and he covered it. He said that there would be negligence here, maybe, but not intentional acts. When we were here last week, Teddy quoted Dan Waite saying it was negligent but not intentional.
But tell me this though, I'm glad you really brought that up. Because if it's negligent, then what?
Then you just look at prejudice.
Yeah.
And I don't think there's any showing of prejudice here. I think it's hypothetical. That's why I made the argument a few moments ago about the fishing expedition. There's nothing concrete here. Remember in Nevada Power, Judge White ordered that the sanction without the evidentiary hearing, and the Supreme Court said there's no proof of prejudice here.
Right.
So this party seeking the sanction has to prove,
No, I get that. I mean, that's why I asked some of the questions I asked earlier.
Right.
I understand.
So, I could quote you, I could quote Teddy, I can quote the exhibits, but I can tell that you would feel more comfortable with an evidentiary. So I'm gonna waive my argument so long as Teddy waives his, and we can still get out of here this week.
You know something? Your Honor, I wrote down a note. Given what Mr. Cavanaugh said, that it seemed that he was implicitly asking for an evidentiary hearing to prove negligence as opposed to willful. I think.
That's not, that's
I
not-
didn't tell you.
That's, I know, but I didn't say anything wrong.
Okay, well, then, I will let
We
me
do
say what
not
I
have
got
the
to say.
burden,
I'll let you finish, Mr. You can finish.
We don't have the burden in this
I
case.
didn't say you did. I said what I took from Mr. Cavanaugh's statement. If Mr. Polsenberg is waiving his argument because he believes that the court, I don't say the court, the information placed before the court is sufficient for the court to make a decision, then I'll waive my argument. If he's not saying that, then I'll wait till he's finished and I'll make my closing argument.
Well, it's really simple. I don't think, and I've told you this before, I don't think you have enough here to sustain a prima facie case of a severe sanction. And minor sanctions such as a monetary fine don't require an evidentiary hearing. But
I'm sorry, Dan, say that last part again.
minor sanctions such as, the judge brought it up, minor sanctions such as a monetary fine don't require an evidentiary hearing. You brought that up, Your Honor, and you're right on that. But I'm not saying they've maintained that they brought forward a prima facie case. But we can get to an evidentiary hearing and that will be clear there too.
I got you. I understand. Mr. Parker. And I think what Mr. Posenberg was saying, as far as the prima facie case is concerned, that there's been no establishment of prejudice.
Your Honor, I believe.
Got a question, this in a general sense, I'll let everyone address this, what hypothetically. And Bass Davis, if the court would have said, you know what, I think this was negligent spoliation, would an evidentiary hearing have been required?
So let me answer that question. I think Mr. Posenberg and I may agree on it. We'll see. I believe based on Bass Davis and Young Ribeiro, as well as Valley, that if the court decides to impose a sanction less than striking an answer or a complaint, then an evidentiary hearing is not necessary. That's my belief. Do you agree or disagree?
I think in your circumstance, if in Bass Davis, the defendant said we weren't intentional, we only negligent, and the judge said, I think you're negligent, then there wouldn't be a need for. I think if we were contesting that we were even negligent, you would probably need.
I understand.
Hearing for that.
I got you.
I got 3 lawyers on my side who said we were.
I understand.
So the reason why I believe that the court should hear or hold an evidentiary hearing is because we disagree. We believe that this has been a serial list of mistakes, not negligently, but intentionally. The first one declaration, perhaps that's negligence. 2 declarations, perhaps that's negligence. 5 declarations, no. 2 depositions, no. 3 sets of requests for written discovery responses, no. That becomes to me a pattern and practice of willfully trying to prevent and thwart the orderly process of discovery. That's what I believe has happened in this case. And I believe that Terribles is guilty of doing such a thing for now more than a year. in this case, over a year in this case. In particular, and in terms of these coordinated cases for a couple of years, Your Honor. And in going through.
And I'll just throw this out for everyone to comment on, of course, because I think it's important when for you to understand some of my thoughts. And I think I mentioned this a little earlier, I don't think we really developed it, but what is the role of the trial court, right? And then remember I pulled up the little pamphlet. Nevada Pattern Jury Instruction 2.07. And when it comes to evaluation, because we know how we instruct the jury on credibility of a witness that has testified falsely. And I'm just reading the second paragraph there. And that's why I was asking that one question, what is my role? And we have, and it appears to me that there's no issue of fact as far as whether the declarations and or deposition testimony was accurate. And you notice how I couch that, right? And but then I look at the jury instruction, and this is the second paragraph, and this is after we instruct the jury as to credibility or believability of witnesses. And I read it and I say, and this is the second paragraph, if you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony, which is not proved by other evidence, period, close quote, And so when I look at that, especially under the facts of this case, as based upon the allegations that are being made, one thing we do have that's uncontroverted would be this. It goes to the accuracy of deposition testimony and also accuracy of responses to discovery requests, right? And so under those circumstances, as a trial judge, what do I do?
And so, Your Honor, I believe there's a line of demarcation between discovery and in part the merits of the case.
Right.
And so when it comes to discovery, this court is charged with enforcing the rules of civil procedure. And that's not a decision for the jury to make. We brought this discovery issue to this court because this defendant has prevented us from being able to provide the merits of this case to this jury. And it's prejudiced to the point that it's affected and infected our entire case. Now, this is a point I want the court to kind of put a pin in. Mr. Cavanaugh has conflated what I consider to be causation for medical purposes with a discovery abuse that he believes has no effect on causation. This motion is not about medical causation. This motion deals with Terrible's discovery abuses geared at preventing us from being able to show them in the light that they should be shown, showing this jury how their efforts created this monster and how their efforts, using Mr. Cavanaugh's words, as a seller of products, should have been selling a safe product. But they put profits ahead of safety. And they sold a product that contained hydrazine, which is a known liver toxin. That's what Terrible's did. So you should never conflate medical causation with the relationship it had with Terrible's, between Terrible's and Real Water. And they tried to play down that relationship by not giving us discovery. Now, I will agree with Mr. Cavanaugh in terms of our arguments not being evidence. And that's why I spent so much time showing the court declarations, deposition testimony, because I didn't want the court to rely on my words. I'd rather the court rely on the words of Terrible's employees. The other thing I would agree with Mr. Cavanaugh, and I think he's right on this. We cannot vouch for the integrity of our clients. Mr. Cavanaugh has spent a lot of time telling us about how Terrible's has created this business in Las Vegas. And we don't deny that they've created a large business here. It's a large company, over 100 stores. But that has nothing to do with discovery abuses. And so, Your Honor, his attempt to persuade this court or vouch for the integrity of their executives is inappropriate. The court needs to weigh that in determining how it should enforce Nevada Rule Civil Procedure 37. Because we know that they violated through their admissions today, Rule 34, on several occasions over several months of time. They violated Rule 16.1. And their attempts of providing information to us on the eve of trial, and the eve of the discovery close of discovery, is inappropriate and has put us in an untenable position. Terrible's had a relationship that we've now been able to further reveal through these documents dealing with marketing, promoting, displays, commercials, coupons. Going back to 2008 now. What we've done in prior cases, and I think this is why Terrible's it's done. We've developed this industry is a billion-dollar industry, multi-billion-dollar, of which Terrible's is a part of it. And in terms of punitive damages, we will be looking at Terrible's for punitive damages because of its relationship with Real Water. The last jury gave us 3.1 billion in punitives. Real Water was, of course, the defendant in that case. Terrible's is the defendant in this case. And we expect that Terrible's is trying to avoid and distance itself from Real Water because it doesn't want to be subject to punitive damages. And so that's been what I believe to be the reason behind their misconduct. Now, we need to have those witnesses on the stand. We believe it would be the 4 witnesses that we've already examined, as well as Ms. Kayla Adams so far. Mr. Sexton, Mr. Kemper, Mr. Breeden, Mr. Walters, and Kayla Adams. We might also bring Anthony Randolph, but we're not certain on that. But we believe we can do this in a day, Your Honor. And what I also want to point out, Mr. Cavanaugh has now said that those documents should have been produced. And we agree. They should have been produced long before July 24, 2024. His references to my email, when he brought that up, I actually was pleased because the words used in paragraph 5 on page 2 of this document were the names and the words that Your Honor has now seen through our written request. So this should have been done long before we had to beg for it, because the rules required them to do it. While I was sitting here listening to Mr. Cavanaugh, Your Honor, I looked back over the evidentiary hearing and looking at some of the testimony given during actually the examination by Terrible Herbst's attorney of one of the Terrible Herbst employees. And looking at this, I'll tell you what page it's on. It's it's the examination of Mr. Sexton by Ms. Rojas during the evidentiary hearing. And she asked Mr. Sexton, in your recent search of the document productions, did you actually look at any of the documents? He said some of them. And did you see emails related to the 2020 coupons? I don't recall. And in September of 2023, when you were conducting those searches, that was a company-wide Is that correct? Yes, ma'am. And is that true also for your November 23rd? I'm sorry, November 2023 search? That was a company-wide search. She says, yes, ma'am. I'm sorry, he says, yes, ma'am. Your Honor, when he did that search, which he's telling his attorney during examination under oath, he said he did a company-wide search. Those documents should have been produced then, but were not. He also says that when Kayla Adams, who worked for Brian Breeden, did her search, she included the online archives. So when Mr. Cavanaugh was talking about archives, they checked those in preparation by Ms. Adams, in preparation for responding to the Henry discovery. And those were discussed again during the evidentiary hearing. Your Honor, every deposition testimony, all the deposition testimony by the two Terrible Herbst employees and all the evidentiary testimony indicates that they did searches for each of these employees' emails and did not produce these documents. An evidentiary hearing will flesh out whether or not it was negligently done or this was a willful obstruction of the discovery efforts on the part of Terribles. And I'll give the court another example. It says here on page 210, so when you were searching the emails in September of 2022, would that have included Mr. Breeden's emails, for example? Yes, ma'am. Would that search in September of 2023 have also included the search of Mr. Walter's emails? Yes, ma'am. And would your search in September of 2023 also have included Mr. Kemper's emails? Yes, ma'am. Would your search in September 2023 also have included Kayla Adams' emails? Yes, ma'am. And Kayla Adams is the director of marketing and works for Mr. Brian Breeden. And did you also conduct a search in November of 2023? Yes, ma'am. So we're sitting here listening to these witnesses, Terrible Herbst executive employees, saying that they conducted, this is a chief information officer saying he's checked every email as of that day. Company-wide search. These 271,000 pages should have been produced, Your Honor. Whether it's when willful or negligently they failed to do it, that's something for the court to decide because the court enforces the rule. In every case that we pulled up, the court is making that decision, not the jury. So, Your Honor, I believe, and I have several other items, other points within the record that I can point to, where each of these.
And you know what,
employees are saying
and you
the same
know,
thing.
here's the thing, I was actually thinking about it, and I can't say that today's time was excessive. And I was thinking about the prior case we had, and we talk about prejudice. One of the real components of due process is the opportunity to conduct a meaningful deposition with all evidence in front of you in preparation. That's part and parcel of due process. But just as important too, we've had some testimony that has been recanted, right? We have. And here's my point, and I think this is a very valid point. I understand Mr. Polsenberg said, well, prejudice. Well, that's part of the prejudice, is not being able to take a meaningful deposition. But I'm looking at it through this lens, because at the end of the day, we don't know specifically what happens when witnesses are put on the stand and they're tested. And the reason why I say that is this, and I was listening to all of this, and I just remember in the last trial, we had a representative from, I want to say Hannah Instruments or
From
Milwaukee. Was it
From Hannah.
Hannah, right?
Mr. Carl Savaggio.
Mr. Carl Savaggio. And so when Mr. Savaggio was on the stand, we kind of, I mean, it was, everyone thought that his testimony was going to go one way. And lo and behold, under the pressures of cross-examination, we found out a lot of information that no one knew about, right? And when I look back at that, I just thought about that as you were talking, and to be candid with everyone, I think from a judicial perspective, it probably would be error for me not to permit a evidentiary hearing. I do. And I think Mr. Savaggio is a really good example. Because under the pressures of examination, what happened?
He admitted that there were tests that he never produced and had never identified.
Right.
No one knew about it.
Nobody knew about it. Which I know that's up on appeal. I won't say much else, but I think that's a really good example because you don't, until people testify and why didn't you produce it this, you don't know. Right? And at the end of the day, that's what happened. There was never an opportunity to dig deep and ask important questions and the like. But Mr. Savaggio is to me the reason why I think I have no choice in this case, but to grant that.
I appreciate that, Your Honor. Has Your Honor considered your calendar?
No?
I still need to answer the question you asked both sides.
Yeah, you can, Mr. Polsenberg.
So you asked about Nevada pattern jury instruction to
As far as my role, yeah.
and you mean your role as
Yes.
opposed to your role versus the jury.
Exactly.
This doesn't go to the jury. I
No,
agree
no,
with Teddy
no,
on
no,
that.
no, no, no. I wasn't saying, no.
Right, but remember though, there are two competing jury instructions out there on what do you do when a witness lies.
Right.
One even older than 1986, the Clark County says if a witness lies, you are to disregard everything he says.
And
And this one says it's up to you.
that's right.
So
I'm not following Clark County.
So-
If that'll make you feel better.
you've got the witnesses, you can say, you know, when I read it on a piece of paper, I thought this guy was a lying sack of baloney. But now I listen to him and it's like, yeah, I understand why he made that mistake. Joel Henriad likes to quote George Costanza, who says, it's not a lie if you think it's true. And Joel would say that in the hallway and laugh, and I'd say, well, you know, really, I mean, look at it from a philosophical, moral standpoint. It isn't a lie if you think it's true. Because the difference between a misrepresentation, which can be intentional or negligent, and a lie is a lie, you're saying something you know is not true. So yes, it does make sense for you not to judge them extremely on a piece of paper. If you're gonna
That's
judge
exactly where I'm going, Mr.
Yeah.
Polsenberg.
Oh.
That's,
Totally. Well, Teddy gets up here and says stuff about medical causation, and I don't know what he's talking about. Remember,
well, I only think it was brought up because causation was mentioned.
causation, yeah, of course, causation is an issue, not medical causation.
Well, that's
It's-
also an issue in this case, but
Sure.
not what I was talking.
I got that. Don't make me disagree with you and him. So, remember, it used to be for negligence, and I know we're probably not talking negligence here unless it's a joint venture. It's duty, breach, causation, and damages, and there are 3 Nevada cases that say there are 5 elements: duty, breach, cause, in fact, legal cause, and damages. So Jim's point was the advertising is irrelevant since Mr. Henry's mother didn't see the advertising. And I think that goes to prejudice.
Well, you know, the thing about it though, when it comes to, I understand what he's saying, but whether the mother saw the advertising or not, or even the consumer, that's not the real big issue because we're not, I don't think there's any allegations of misrepresentation as far as the product's concerned, anything like that. I think really and truly, what my thrust and focus is going to have to be on what relationship, if any, there is outside of a traditional manufacturer and distributor.
I think you and I are saying 2 different things. Just bear in mind when we get to the evidentiary hearing what I'm saying, because we could say yeah, sure, we were involved in the advertising, who cares?
But,
It
but
played
that's
in-
kind of my point, though. I mean, and understand this. I'm not necessarily saying advertising is enough to change the manufacturer-distributor relationship. Example, you go into any supermarket and it comes to product placement, the vendors bring their stuff in, they put it on there, and they might have a little sign they put in that. I get it, Dan, I do.
Okay,
Mr. Poe, yeah, I get it.
right.
I understand that.
Okay, so they still, even now in rebuttal, 5 hours of argument and then a rebuttal argument, they still haven't shown what the prejudice is. You asked about, you said Mr. Polsenberg thinks going to prejudice until he gets up and he says, well, yeah, negligence versus intentional. They've not shown the actual prejudice. And Judge, now they tried 5 hours in arguing the motion, they never brought it up. Now they're trying to loop it in for punitive damages. I'm gonna tell you right now, you can't strike our answer as to punitive damages.
Yeah, I'm not going to, my mind's not made up on anything. I kind of look at it slightly different.
Can't deny us a full trial on punitive damages.
Yeah, I I actually kind of look at it a little bit differently in this regard. I don't know. I kind of with, you know, and I'll just leave with, I think I know what's going on here. I think it's slightly different than that. But go ahead. I do. I don't think that's what they're trying to do.
So.
You can ask Teddy what he's
But
trying to
if
do.
they listed the 5 witnesses they want to have. None of that's gonna go to prejudice, so you might as well deny their motion right now. They have to show prejudice, Judge. Thank you, Your Honor.
All right. Last word.
Thank you. No, Your Honor, I think we're
But I
fine. We
think
just need to-
Savaggio is
we-
the perfect
we-
example,
we-
and that's why they weren't able to test the witnesses based upon the materials.
Then have them test the witness based on the material, Judge. You can't. The reason you thought that witness was so unusual and you remember it is because that witness was so unusual. You can't take a 1 in a million case and say, well, maybe it would happen here too. You have to.
But that goes, but you harp on due process, and that, to me, that goes to the fundamentals of due process, because number one, they testified there was nothing there. There's no, right? There's nothing there. And then they answered discovery, there's nothing there. And then they recant. You notice I said, I didn't say anything else. I said they recanted their testimony. Now, and have you had an opportunity to test them on why they recanted their testimony?
We will give it entry here. We're both pointing. to-
Go on. There you go.
That's where we're gonna go. I'm gonna ask the court when the schedule.
Yeah.
We're both pointing to the witness.
I am looking
Now,
at the witness stand.
You know, and interestingly, that's one we all three agree on, once I crystallized it,
That's
right?
right.
Well, I don't think they've made a prima facie case. I don't think they've shown prejudice. I don't think they have shown that there even was they argue it should have been produced, but that is not enough to get a sanction. I disagree on their rule,
You can make that argument, Mr. Polsenberg. I'm not stopping you from doing that.
and I'll make that argument.
Yeah.
Oh, yeah.
You can make that argument,
Very good, thank you, Your Honor.
yes.
You know, we addressed prejudice. We had a whole list of prejudice that we discussed with. the
How
court.
much time do we
You
need
didn't-
from a
you didn't
preparation?
show it.
What I'd like, Your Honor, I think we need a day for the actual evidentiary hearing itself, maybe a little bit more than a day, but I think primarily we can get it done in a day. The only problem that we have is, you know, we have a busy week next week, so if we can fit it into next week, I'll do
Well,
whatever we
we're
can.
not gonna, well,
If
I
we cannot-
probably will need 2 days for the defense of it.
So if we can't do
So
it
if
next
he thinks
week,
he can't
whatever
do
the
it
week.
in a day, that's not even counting my time, so yeah.
Well, we have to have a fair opportunity to meet with our clients' witnesses.
Right.
We have 15 expert depositions next week. How we could fit it in,
You guys
he's
can-
good, but I don't know if he's
All
that
we can
good.
do is settle this, right?
Can I pick the one you take?
No.
Mr.
We
Polsenberg,
have
you
pretrial
don't
motions
take
due
depositions
tomorrow.
anymore, do you?
That's below Dan.
You don't take, that's what I'm getting ready to say. I didn't think so.
It's a level of non-deposition take.
When we get off the record, I'll tell you about the only case I did depots in recently.
So Your Honor, when does your schedule permit?
I asked Tori, I don't know.
I was looking at Tori.
Should we do a
Side eye,
doodle?
didn't know she's giving
Should we
me
do
a
a
look.
doodle poll?
We have pretrial motions due the following week after the experts.
What is this set for trial?
October 7th.
Okay, well, at least it's not September.
The first available that we have is August 23rd. That's a Friday and we
Next
can do
Friday.
all day.
I have to defend
That's
and
our
be
first
part of
available.
2 or 3, okay, I'm just, that ain't gonna work.
Yeah.
Anything in the next 10 days likely is.
Judge, I've got a very big case for argument on September 3rd. I have a moot court on the 23rd.
Can you do anything after that following week, the week of the 26th
Of
of August?
The only thing that we can do the week of the 26th is August 30th. That's another Friday and we have all day.
August 30th?
I think I have another moot court on August 30th, and Jim is right, we've got to check with a bunch of witnesses that we haven't even talked to.
It's to have this be a fair.
So we
hearing.
probably need more than one day.
Our trial stack begins September 3rd, so that would be the following week for our September stack, and we don't know what that schedule is going to look like until this upcoming Thursday with our pretrial calendar.
But here's an important point. If I said something that first week, then I tell the lawyers that week's taken.
That's big with that, Sean.
Yeah.
So you
as
wanna
long
get
as
it,
it's
you wanna,
not,
because if you snooze, you lose. Isn't that how that goes? Yeah.
Those Latin phrases always confuse me. So I have this big Supreme Court argument, I think I said September 3rd, it's September 4th. But if you gave us the 5th and the 6th, we have to check with witnesses. And
We can only do the afternoon of the 5th,
That's fine. Can you do the all of the 6?
all of the 6th, yes.
I don't mind.
and we're probably gonna need 2 more days beyond that.
We have to start somewhere.
I'm fine with starting on the 5th, I believe, John.
At least clear the hearings, I mean, the depositions, they're
Yeah.
gonna spill over past the 23rd.
Yeah, it'll have to
So,
start
and the
somewhere.
pretrial motion, so I think the 5th and 6th could work.
Oh, we
Yeah,
have to
need 2
start
more
somewhere.
days beyond.
And we'll discuss that at the time. We'll see how the testimony goes. I mean, I don't know. But we have to cement in those days. Or if you
We'll
don't,
start those 2 days.
start those 2 days.
All right.
Thank you.
So
And if it takes more time, it does. Go ahead, play.
The 5th will be at 1:30 and you want 9:15 on the 6th, that's a Friday.
Yes. Sorry, Mr. Cavanaugh, no 10 o'clock.
I walk the dog sometimes at 5:30 or 6:30 in the morning with the heat.
Oh, yeah,
How about you?
but it's getting nicer now.
Yeah, no, just it's turned a little bit.
Yeah,
I think you turned a corner.
absolutely.
So the motion is granted with regards to the evidentiary hearing and denied regarding the striking of the answer.
I know, it just say that the judge has ordered an evidentiary hearing on the motion.
I agree. Thank you.
There's no
That's
grant.
fine.
Okay, no granting or denying?
No, granted,
Although
nice.
I'd love to have it say, yeah, denied as to striking the answer. I'm not sure I could get that
I
one.
did have one more question. So the exhibits that you presented, Mr. Kavanaugh, D, E, and F, were you just, well, I don't know what you want to do. Are you moving them for admission or are you just calling them next in line to your motion? Cause there's a difference with
I
with
think-
admission, I have to stick them and take them to the vault and all that.
Now, I think next in line to the motion, I had 3 exhibits attached, my opposition had 3 exhibits to my declaration. And they were A, B, and C. I want to make these D, E, and F.
To the
attached
motion.
Are they being
to
admitted?
my motion, opposition, declaration.
So we don't need to have them as a court's exhibit, we
Okay.
can file them
That
as
works.
DE.
Okay,
And then they'll be part of the record.
Yeah, that's exactly right.
thank you.
Thank you again, Your Honor. We appreciate it and
Thank
sorry
you.
for taking so much time.
Great, do I get the PowerPoint, Judge?
So it's
I'll have, can you get his?
1:30 on the 5th or 1 on the 5th?
1:30 on the 5th, 9:15 on the 6th,
Okay.
and that will be in the minutes.
All sides?
And we will agree to the order of the witnesses among ourselves.
That's up to you. That's, there might be some logistics involved in that, so.
Agree to the order of the witnesses.
Yeah, we'll talk about that, Your Honor.
All right.
So Your Honor,
I'll listen to hear back from Mr. Cavanaugh in terms of the availability of his witnesses, and then
Is there a necessity for an order for today?
No, I think a minute order saying that you've ordered an evidentiary hearing is enough.
I think so.
do we need to subpoena your witnesses, or are you gonna make them available with us?
I'm gonna make the witnesses available without a subpoena that work at the company still.
All right, that sounds good.
who does it?
And lastly, how many witnesses do we anticipate?
Your Honor, we
I don't know yet, but I'm gonna have a few.
We'll figure it out. I'm sure they'll tell me before.
See, I'm not as concerned about this in this regard because this is the case where I have the record of, what was it, 20, how many witnesses again, Tori, in 1 week?
29, I think.
29 witnesses testified in 1 week.
That's right.
I had the first trial I ever did after the shutdown. Judge Delaney, we had 7 witnesses in 1 day, and it was the first remote trial I ever did. That's the one where my dog barked.
So Tori, I'm to file my 3 exhibits to my to the motion. Just file them and call them supplemental exhibits.
He doesn't even have to worry about it because it's a filing thing, so I'll explain to you.
Yeah, yeah.
All right.
We don't.
Anything else?
Good.
She's good. I remember when we had the remote hearings during COVID and occasionally my dogs would bark.
Judge
What do you
Delaney said
do?
next, we're gonna hear his toilet flush. I probably should have gone off the record.
Record.
Thank you, Your Honor.
Thank you.
You're welcome.
Thank you so much.